Tennessee State Board of Barber is now called to order. May we join in for prayer.
In the name of Jesus, Lord, we thank you for this day. We pray blessings on this Barber board and all that make this board up. Pray blessings also on our member who is not here today. And we thank you for allowing us to be here to do the duty that you call us to do.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Roll call, please. Starting to my right.
Donald Collins.
Larry High. Joe Jones.
Ron Gillihan.
Okay. Minutes of our last meeting. Can we have a motion to approve?
I make a motion that we approve the minutes of the last meeting.
A second. It's been moved and proper second that we approve the minutes been read. All in favor, say aye.
Aye.
Any opposed? All say present. So the motion's carried. Okay. Hearing before the board, Ms. Roxanne, do you have?
Thank you. I sure do, Mr. Jones. Thank you very much.
Okay.
Just a quick update. As we all know, the May 19th board meeting was canceled, and so we've got all the items that were to be presented then and have added anything since then. So today appearing before the board is Mr. Shalabi Abdul Rodriguez. Mr. Rodriguez appeared before the board on the 19th and had a moment to have answer some questions for us, and he's returned again today. He is here because he's previously been presented for his application for reciprocity of a license, and at the last meeting on April 21st, he was denied. Both times the board voted to deny the reciprocity application. In front of you is a letter that he has put together, also a copy of his certification from Illinois, which shows that he's been licensed since October 17th of 2013. Also provided is a breakdown of the educational hours that he obtained in 2006, which is a total of 2,000 hours outside of the United States. He's available to answer the questions regarding his schooling and work experience. Mr. Rodriguez, if you would come on up. And he's asking that we reconsider the hours or the reciprocity, whichever way the board decides to go.
Okay. Good morning.
Good morning.
Good morning.
Glad you're all there today.
Doing well.
Okay.
Thank you.
Can y'all hear me well now? Okay.
Yes.
When the
I
red
was-
light's on, that means
Okay,
you're
thank
broadcasting.
you. Thank you. I was looking over your application, and you have quite a bit of training in hair cutting, hair relaxing, hair coloring, facial cleaning, perms, and blow drying. I don't see anything in terms of theory, in terms of hygiene. I'm concerned about that.
Sorry, I didn't really get your question.
About hygiene, I'm talking about, for instance, your skin, the dermis, the epidermis. How do you protect your customers? How do you protect your customers from dirty clippers? That type of thing. I don't see any training in that. What I see is practical training, but not theory training. In order to have a license in the state of Tennessee, you must have two parts training. Theory is what I'm questioning you on, and practical is what I see here. So did you have any theory training?
I did have it, and I went to Chicago, and I switched it from overstate, like from overseas,
Huh?
to Chicago license, and which is I passed the test.
Okay.
And that's when they gave me their license.
Okay.
I came down to Memphis because I have a barber shop over here, and my whole family's over here.
Okay.
And I got already 3 barber license working for me.
Right. Well, I'm sure.
I would love to stay in Memphis. Now I'm licensed up like Illinois. So I can
Yeah.
I can go and work in Illinois. You know, like nothing. It's already like licensed up. Like I can go and work in Illinois with no problem. So I'm just trying to switch it from Illinois to Memphis, Tennessee. I passed all that. Of course, the haircut and everything. Like I'm ready to do a test over here. I'm ready.
I can see you have your hours in hair cutting and hair relaxing, hair coloring, facial cleaning, perms, and blow drying techniques. I see that, and it's great. You'll have some high scores on your application. I'm just concerned about the theory, the part of hygiene. You know, in Memphis, there's a we have a Shelby County Health Department, and because I'm from Memphis, and so I don't see anything here. I know we have one board member that's really serious about hygiene, and of course, if you would take the theory part, if you had training in the theory part, then you would know about that. So I'm just concerned about that. I really thank you for coming, but I'm just concerned about that. I just thought I'd ask you that.
Yeah, I know, but let me get back all the way to like before a year. Actually, I send over my resume from overseas from Israel.
Okay.
Which has had all that on it.
Okay.
Which is already past all that.
Okay.
And if you look back at my resume before, like, yeah, I did ask for that and I did send it, and I sent all my hours breakdown, that was like a year ago, but this is the second time. So I got like the Chicago, Illinois one. I'm sorry. I got the Chicago, Illinois one, and I got the Israel license up. So I got actually both of them. If you look at them, one of them was last year. I don't know if y'all still got the if y'all still got the envelope for it, which is exactly tell you that I have the breakdown hours for that.
Mr. Collins, I wonder if then, since we're not comfortable with the information regarding the theory, if your decision could be for him to test and take the Tennessee examination.
That's what I was.
He took him past the Illinois portions, which cover theory, but
Okay.
if that doesn't leave us comfortable with the actual credits and knowledge of all the theory and the transmittable diseases and sanitation, if the board would vote to approve him, then to take the examinations.
Do we have anything from Chicago that would say that Mr. Rodriguez did pass the
He
theory
did.
part?
He
He
took
did
the
present that?
exams, right.
Because I don't see it here.
Mr. Collins,
Okay.
it's on your iPad. There is a certificate,
Page 8.
page 8, from the Illinois Department of Financial and Professional Regulation Certification of Licensure. And it shows that Mr. Rodriguez's Illinois license was issued on October the 17th of last year, and
Yes.
it is valid through 7/31/15.
Okay. So that means that he did test for the theory part
And practical.
and practical and passed them both.
Right, they accepted
Okay.
his hours.
Okay, that's fine. Then that just clears it up for me because I didn't understand it.
Okay. There's another problem here. I don't know whether Illinois and Tennessee, as far as reciprocity, recognize one another. Everything he have here is from cosmetology, from the beauty school, Illinois. So that's my concern there, the difference between Tennessee and Illinois. And so according to this, he have his license probably states cosmetology.
No, it's a barber license.
It's
On
a barber
page
license?
8, yeah, it's, profession says licensed barber.
He passed the Illinois practical and theory, right?
Correct. And if we're not comfortable with that, given that we've denied him before and you want him to take the Tennessee, that's an option. And at least then we're accepting his hours. If not, we could accept him by reciprocity, given that he has an active license in Illinois with the same requirement of hours.
Well, since we
And
have
he's passed that number.
I'm sorry. Since we have proof that he passed the practical and the theory, I see no reason why we shouldn't grant him his reciprocity.
That was my only concern was the theory issue. So yeah, okay, good.
Have anything on it?
I agree.
Okay.
I think we should offer reciprocity.
Okay, let's have a vote on it.
We need a motion
Motion.
first. And
I'd
if
like to
the-
make a motion that we grant Mr. Rodriguez his reciprocity.
Motion, do we have a second?
Second it.
It's been motion and second that we grant him the reciprocity. All in favor, let it be known by ayes.
Aye.
Opposed, same sign. The ayes have it, motion is carried.
Congratulations.
Yeah, very much.
You're welcome.
Y'all don't know how I have, but I just want to give each one of y'all 100 kisses in. Like,
No kisses, no kisses, okay?
Really, thank you very, 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 very much.
Go home and kiss your family.
Yeah.
Man,
him and
thank
him
y'all.
and-
Thank y'all. I feel like y'all
Yeah,
family
4
right now.
times.
Thank you very
You're
much.
welcome, you're welcome, you're welcome.
Very much.
Thank you.
All
Next
right.
on the agenda, we have a change in school ownership form. Music City Barber School is applying to change the name of the school only, and that's for accreditation purposes. I wasn't sure if Mr. Wani would be able to appear before the board, but again, it's a change for NACIS accreditation. They wanted it under the LLC name. And I do need a motion for you to accept that, please.
Been moved.
A second.
It's been moved and properly second that we accept this certificate. All in favor, let it be known by voting sign of aye.
Aye.
Ayes have it, and motion is carried.
Thank you. Next are
Thank you.
applications for examination. We have in front of you information for Mr. Eric Kane, Nadia Kofer, Davius Hewlett, Marvin Hoger, Santus Holmes, Daniel Jenkins, Travis Jones Jr., Adam McKay, Romario McKinlan, Travis Neal, and Ricky Stewart. All have felonies and are submitting before the board documentation for your approval. The required information, the disclosure of student information, letter of recommendation from the school is all submitted. If you have any questions, Mr. Daniel Jenkins is here before the board to answer his particular situation, and I'll give you some time to look over the documents.
Take a little time and look over. Okay.
iPad just
Do we
went on
have
and said the battery's low.
Oh, is it?
Battery
Got an
low.
extra one.
Do we have any questions with, do we have here?
Jones, if no board members have questions, I did want to point out a couple things about two of these applications that caught my attention just for the board to consider.
Okay.
The very first two applications, one is for an Eric Kane, the other is for Nadia Coffer. I'm well aware of and am in agreement with the board's stance to try and give people second chances and to, allow them to turn their lives around. At the same time, I think it's the board's responsibility to look at the seriousness of the charges, and Mr. Kane's charges include sexual exploitation of a minor, and Ms. Coffer's charge was attempted first-degree murder. So while I'm not necessarily saying that the board should outright deny these folks, the board may wish to consider, instead of a 2-year probationary period, something like a 5-year probationary period, just to give the board a little more time and opportunity to oversee and keep a close eye on these folks, because those are about as serious as crimes as there are.
Right.
And so if it's the board's inclination to give them the opportunity to turn their lives around by practicing as a barber, then my respectful recommendation would be for those two for a 5-year probationary period.
Also, I'd like to add to Mr. Coffin, he has a cosmetology license also, so that's not the barber's license. I don't think we would even act on that.
No, sir, that's a separate board, separate matter.
I did have a question on Santos Homes. Didn't seem like there's a disposition. On Santos Homes, I didn't see a disposition of that case. Has it been probationary period completed? What's the outcome of that?
That's Mr. Santos Holmes. All the letter from Mr. Holmes says is that he had felony charges, aggravated burglary, 1995, but unlike the other letters, it does not appear that there was any description of the disposition, because most of the other folks say, I was on probation for this amount of time, I served this amount of time, I'm now out. Or previously they would say things like, I'm scheduled to be released in a few months or something, but that's not in here. So
For that length of time, would it be safe to assume that would have been dispossessed, depending on?
for that charge, unless this was a multiple time offender, it is more likely than not that any prison term and probationary period are over, absent other charges. But if the board would like to say something like, we would vote to conditionally approve with the 2 years pending receipt of information from the applicant about where they are now. Just, say, hey, look, we need to know if you're still on probation, if you've had any new charges since then, are you currently on probation or anything like that. And once you receive those answers, I think that at that point the applicant could be treated like any other and get the standard 2 years.
Also on Mr. Holmes, I don't see where he ever obtained a master license. I don't think he ever took the test.
No, sir.
If I'm reading.
All of these individuals are requesting approval to test.
Okay.
Once they sign the consent order with the 2 years, or if we extend it longer, then we submit them to PSI and approve them to take the examinations. We've gone to that just so that no one takes the exam and then for some reason could be denied. then we approve them ahead of time.
Just like Chris said, we had already previously said that we would look at the application and see the nature of the crime and see that some should be added more than just 2 years. So I'm totally in agreement with that. We need to look at the nature of the crime because, like I said, we might need to put some of them 5-year probation.
Travis Jones also was a second-degree murder.
He is currently in the prison. He's wanting to take the exam. I think he's going to be there at least 8 more years, is my understanding. I actually spoke to his instructor. He was one of the felonies that were to be presented last month, so he's anxious to test because he's wanting to work there inside the prison.
Callahan, given the severity of that offense, then it appears that Mr. Jones would also be an appropriate candidate for the 5-year period.
Have any more run? Okay.
Jones being incarcerated at this point, and we 5 years probation, that would also cover his conduct while he's incarcerated. Is that correct?
Mr. Collins, I believe that would be 5 years from the date of license issuance. So whenever the license gets it, they have to sign the consent order, pass the exam, and then when the license is issued, that's when the time period starts running. But what I guess I would add to that is if Mr. Jones is going to be incarcerated for the length of time that he may be, then there will be far more stringent supervision at the jail than
East.
That's
Exactly.
correct.
That's what I'm looking at.
So
I mean, is it any way we could at least allow him to take the exam with the 5 years, but once he's released, I think it still needs to be something imposed because, I mean, while he's incarcerated, of course, he's under strict supervision, but once the person is released, I mean, he's virtually on his own. I'm just making a suggestion. I don't.
Well, then I guess a potential compromise on that would be due to the seriousness of the offense, if the board wishes for when Mr. Jones is released, whenever that is, for him to come back before what will at that time be the Cosmetology and Barber Combined Board and appear personally, so that board may ask him any questions that they want to ask him upon release, see how he did while he's in prison and things like that.
And will he be allowed to take his board test while he's incarcerated or after he's out?
While he's there, that
While
person
he's-
has
while
an
he's
arrangement
there.
on PSI, they go to them, yes.
So this probation will start actually after he's released, is that correct?
No, sir, it would start at
Start
the
right
date-
then and there, the
the
day
date
he's
of-
issued the license?
That's correct.
Okay.
Okay, looks like we need to take some of these separate. What is it? At least three of those.
Mr. Eric Kane, Ms. Nadia Kofer, and Mr. Travis Jones Jr., I believe from our conversations, we are wanting to do 5-year consent orders for probation. Okay.
And for Mr. Jones, his will include a personal appearance before the board that has jurisdiction at the time of his release.
Okay, first we get the ones with the normal, 2-year probation. We get those first.
Let me reread those to make sure that we're not missing anything. For the
Okay.
2-year probation, at this point, we are considering DeVias, Hewlett, Marvin Hoger, Danielle Jenkins, Adam McKay, Romario McLean, Travis Neal, and Rookie Stewart. Those are all the normal 2-year consent orders we've always done.
And with Santos Holmes, if he's included on the 2-year list, that is conditional pending receipt of information about his, the current status of whether he's on probation or parole or anything like that.
Do we have a motion to approve the consent orders on those individuals?
I'd like the motion that we approve the consent orders of the individuals that you just named.
Perhaps second.
Second.
It's been moved and second that we approve the 2-year ones. All in favor, let it be known by saying aye.
Aye.
Any opposed? Ayes have it. Motion carried.
Separately, we have Mr. Travis Jones Jr., who's currently incarcerated. We are going to do a 5-year consent order with the condition that after he is released, he appear before the board to petition again for the license. And do you want to say to ask for the license or simply to state where he's at?
It won't be a petition for the license because he will already
Already.
have it.
Right.
It's actually just because the way the statutes read, the board may impose any other lawful conditions, and the board always has the right to ask an applicant to appear in person to provide information. So I think that's a good thing to do in this case, even if it's just to say, okay, for the future board, how did he do in jail? Did he do well? Was he a model inmate? Did he do well in the prison barber shop and all that? Just so that they know whether, okay, this looks like somebody who's rehabilitated or it's somebody we need to kind of keep an eye on and not.
With the possibility of imposing another 2-year probation.
I believe that would have to be through the normal complaint process, and I think that would probably require some future misconduct on the part of Mr. Jones. But certainly, if that were to happen, that future board could take whatever action it deemed necessary.
Okay, vote on,
We need a motion regarding Mr. Travis Jones Jr. We are going to make his consent order for 5 years, and we are going to add that at the time of his release from incarceration, he is to appear before the board.
Prior to beginning practice outside of the jail.
do we get a motion on that?
I'm sorry.
So moved.
Second?
Second.
It's been moved and proper second on Mr. Travis Jones Jr. All in favor, let it be known by saying aye.
Aye.
Opposed? Ayes have it. Motion carried.
Thank you. Next, we're looking at our miscellaneous, and we have a request.
We gotta do Kane and Coffer.
We did already,
You did that?
for the first one, so
Can I
we're.
make a statement before we move any
Yes,
further?
absolutely.
Did you not say we have Mr. Jenkins in the audience today?
Yes, he's here, sir. Did you have any questions or want to?
No, I
speak
just
to?
want to thank him for coming.
Thank you.
Thank you for showing up. That's volumes for you. And congratulations. Okay. Thank you.
Thank you. On your iPads, we are on page 58. There's a letter presented for you that I would like you to take a look at. This is a request from Mr. William Chandler. He is requesting the board consider waiving the large penalties on his barber shop license due to incorrect information communicated by a former inspector. He provided the letter detailing the information he received. Mr. Chandler is the owner of a licensed cosmetology shop since 2004. That same shop became licensed as a barber shop in 2010, and it was due for renewal for the first time in January 2012. Pursuant to Rule 0200-1-.11, barber shops' licenses continue to receive $200 penalties for every year after they are late. He was under the impression that since he did not have a master barber, there was no need and nothing else for him that needed to be done until he hired one, and so consequently, he did not renew that shop license. He currently has a master barber he is wanting to employ. He therefore applied for a license and for the first time found out the penalty he had to have. So he's asking for you to consider waiving that, and in which case he would pay $125 to renew late, if the board chooses. Otherwise, he owes $600.
Had he had any problems with his license before?
No, not at all, not with his or his cosmetology shop. And he really trusted the inspector's information. I just think it was a miscommunication between the two of them, probably.
whenever his barber left and he just stopped doing business, he didn't renew.
Correct.
And then he wanted to bring it back in.
And he thought it was that simple, yeah.
Well, in my opinion, I would think, whatever the board, if you want to discuss it, in my opinion, I would think we should waiver that and just let it start all over from new. What, any discussion on that?
I agree with that.
Okay, can we get a motion on it?
If I could clarify, Mr. Jones, then you're agreeing to waiving the excessive penalties on the additional years and keeping
Right.
it at the 125? Okay.
Uh-huh. Yeah.
I'd like to make a motion that we waive the $600 penalty and allow him to pay the, whatever the late fees are, right?
25. I second.
Been moved and second that we waiver the $600 penalty and he started with the 125?
Yes,
Yes.
perfect, thank you.
All in favor, let it be known by saying aye.
Aye.
Motion's carried.
We will start our applications for reciprocity. I have information that I'm actually going to hand out in paper for our applicant, Mr. Jared Anderson. He is here before you today. Let me hand these out. Thank you. Mr. Anderson's requesting reciprocity from the state of Alabama, and unfortunately, his certification from them has yet to reach the board. He also appeared at the last meeting that we canceled, and I guided him through the process. At that point, he had not completed an application. He had not contacted Alabama. And so the reason he's appearing today is for an answer, and the license that he has with Alabama is through apprenticeship hours. And so because he is ready to move on and has a job pending, he would like the board to review what we have in hand. We obviously, again, don't have anything directly from Alabama, but the last letter states kind of that he's worked since January of 2012, and the hours, because there's 3,000 of them through apprenticeship, if the board decides that he can be approved to take the Tennessee examination, then once we receive the proper documentation with that approval, we can approve him to test, and he wouldn't have to wait until August. And he's here as well to answer any questions. Alabama is one of the states that has 1,500 traditional school hours for barbering, or 3,000 hours that include the apprenticeship program.
Could he come forward and
Absolutely.
speak?
Mr. Anderson?
So it's like 3,000 hours apprenticeship.
Correct. So you go one path or the other.
My Lord, okay.
Yes.
You only worked under a master bar for 3,000 hours, but you haven't had no schooling at all.
I didn't hear you.
We still have to sit for the exam.
Okay. 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 Me personally, I would like for you to take the exam, of course, whatever the board decides.
Could you,
Exam with no
There you
problem. Yes, I think you can
Thank
probably
you.
pass the exam with no problem. But whatever the board decides, and I think that will save you some time as well. So, but we have nothing in terms of his grades or anything that he did take.
we have his application, and his application tells us the school that he went to. The piece that is missing is the certification from the state of Alabama. It will come directly to us, and we'll follow up
Okay.
in the next couple of days and make sure that we receive that. If the board today does a motion and approves for him to take the examination, we will not submit him to take the examination until we actually have certification from the state. That's the big piece for reciprocity. So without that, we're stuck. So we will try to find out where the delay in that is. If the board decides, then he should be able to, within a week, be able to test instead of waiting until August.
Mr. Anderson, how long have you actually been practicing as a barber in Alabama? What's your history there?
Well, I come from a family of 16 barbers.
You sort of grew up around the business? Okay.
You have any questions, Mr. High?
Kind of confused on this because there's no schooling. And well, that's like JB always stressed on sanitation and things, so I think we should wait until we receive the papers that Ms. Roxanne is waiting on so we can look at that.
Based on what he has submitted, we can tell, if you can look at the one right here, that he has provided his copy of the license itself, or his paying for the license, and below it, he's got a card very similar to what we issue for our master barbers. So from looking at that, that would tell me that there shouldn't be a problem with getting the documentation. And the reason we're doing the paper copy and not the iPads like you normally do is because he just followed up on this and thought, I guess, that we had received everything. But this at least tells us that he does have the license in Alabama. The certification will state 3,000 hours in apprenticeship, which he's already told us he has. If we delay him, he's actually not going to be able to work till way into August. If we approve him, it would be, if the board decides, to test, but only as long as we receive the proper documentation.
It would be until you receive the
Right.
documentation, which
I
should
would
be
not-
coming soon.
It should. I
Right.
don't understand why it isn't here, because at the last meeting, like I said, he was here. He spoke to us briefly with Mr. High, Mr. Gillihan were here. So I would imagine that we'll have it, but I will not put him through to test without the certification from that state.
But after you receive that, he could test as soon as possible?
Correct. That would be the goal. Then he wouldn't be waiting until August, because if he has a job pending, we'd hate to have him delayed.
Okay, and we get a motion to approve for him to take the test.
I'd like to make a motion that Ms. Anderson be approved to take this Tennessee State Board barber's test.
Second?
And moving proper second that we approve for him to take the barber test. All in favor, let it be known by voting sign of aye.
Aye.
Hearing any opposed? Motion carried. So ordered.
Thank you.
Thank you.
Thank you. And documentation will go to him as soon as we receive confirmation.
Okay, thank you.
Okay, of application for reciprocity of a master barber certification from Iraq for Ivan Sulaiman Rajav. Certification verifies barber training course completed between August 2010 and September 2012 outside of the United States. No transcript is provided for barbering programs or information showing the number of hours completed. The applicant does not substantially meet reciprocity requirements. The recommendation is that the applicant be denied reciprocity or provide additional information to meet the minimum requirements. On page 65 is the school information. If it looks like mathematics and a lot of, yeah, it says high school information.
Nothing pertaining to barbering.
Personally, I can't see where we can do much with this without some additional schooling. I don't know what the rest of you think. In the hours that Tennessee requires.
As Ms. Roxanne, you stated, what I see here is classes that he may have taken while he was in high school.
Correct.
Nothing in
Correct.
barbering.
Correct.
So,
And our basic letter requiring more information has been sent to him, but we've not heard back. So that's the reason for my recommendation. We can go any way that the board sees, but I would recommend the denial of the reciprocity, or that he submit us additional information with the hours that are in the field of barbering, and then we could reconsider that. But right now, we don't have anything.
I think we should deny it until we get further information on this.
Is that a motion?
That's a motion. I'd like to make a motion that we deny this until we get further information from him.
I second it.
It's been moved and proper second that we deny this application. Hearing the motion, are you ready to vote? All in favor by saying aye.
Aye.
Opposed? Hearing no opposed. Ayes have it. Motion carried. Denied.
Next is an application for reciprocity for Master Barber certification from Mexico for Joel H. Chavez. Documentation verifies barber training courses completed between August 2009 and February 2011 outside of the United States. Transcript is provided showing 2,500 hours completed. The applicant does not substantially meet reciprocity requirements because licensing requirements are different in Mexico. Included is a letter from Jefferson County, Alabama, stating that he has been working since January 2013. This exception is allowed in Alabama, where they can start working without that license. My recommendation is that the applicant take the Tennessee examination. Page 68 has his transcript, if you will, that kind of shows the number of hours that are in the field.
It shows him having 2,500 hours, but I don't see anything in theory.
I'm with you, yeah. At the top, I don't either. It's natural hairstyling, haircuts and style, 1,600 hours. Hair treatment, 1,200 hours. And then across, again, under a different model, but I don't either.
I get you to get me started again. Thank you. Your recommendation on this was what now? What's,
Take the Tennessee examination.
okay. Board members, what do y'all think? Do you agree?
Totally agree.
I agree.
Agree?
Yes.
Okay. Do we need a motion on that?
I'd like to make a motion that this applicant be required to take the Tennessee State Barber Board exam.
Second.
Been moved and properly second that this applicant be allowed to take the Tennessee exam on it. Hearing the motion and ready to vote? All in favor, known by saying aye.
Aye.
Opposed? No. The ayes have it. Motion carried.
Jones, before we leave the administrative report section, I apologize for kind of keeping us here for a second, but after consulting with Ms. Powers and Roxanna, I went ahead and looked at the rule about the fees that the board just agreed to waive. There's good news and then there's other news. The other news is it does not appear that the board has the authority to waive the fees because it says the fees shall be assessed. However, there is another potential option that I think would probably get Mr. Chandler to the same place, which would be to go ahead and close out the existing license that has the fees and open under a new license number. And, he would not be out any additional money. The same amounts that the board was discussing would be identical. And the only thing that would be additional is, because it would be a new license number, someone would have to go out and look at the shop and make sure that it's still in compliance, which if he's been operating all this time shouldn't be a problem. But that, I think, there is authority to do, whereas the other route, I don't really believe there is. So if the board's inclined to try to assist Mr. Chandler in this way, I think that's the way you guys are going to have to go about it.
Would the name have to change as well?
No.
Okay.
Thank you. Do the board agree to go ahead and, since he have looked that up and take the other route on that, we might need to vote on that.
Just
the
to be
change.
safe, it can't hurt.
Right. Do we-
I'd like to make a motion, that's in order, to allow Mr. Chandler's license to be expired and terminated and issue a new license.
Do we have a second?
Second.
It's been moved and properly second. Already have a vote. Say aye.
Aye.
Hearing anybody opposed? Hearing none, the motion is carried. Thank you. Okay, we are ready for administrative report.
Board members, I think we can go ahead because, if you haven't noticed yet, the legal report is extremely lengthy this time, this being the final board meeting prior to the merger with the cosmetology board, attempting to get as many complaints before this board as possible so the board can consider them, and also to leave the new reconstituted board in the best position possible relative to their complaints. And I think we've done that. But before we get into that, because it's going to take a minute, I'd like to go ahead and have a vote to approve the consent orders, which appear on your iPads after the legal report. Got consent orders for May totaling $1,500 and for June totaling $2,750. And so these are all orders that the board voted to approve the settlements on the terms that were signed off and agreed to. So it's really just a matter of the board confirming its prior willingness to resolve these complaints in this way. So really, I just need a motion and a second and a vote to approve the May and June consent orders.
Okay, do we have a motion to approve the consent order?
I'd like to make a motion that we can approve the consent order.
Motion, do we have a second? All in favor, let it be known by aye.
Aye.
Opposed, nay. Ayes have it. Motion is carried.
Okay, and the other piece of the staff attorney report is the legal report for this month. As you will see, there are approximately 90 cases for the board's consideration, and it's going to take quite a while to read. So, whereas with shorter reports, I typically read them. In this case, I believe if it's acceptable to the board, just have the members read the report and make notes, and then we will address any questions after you've had an opportunity to read the report.
Okay, do we have any comments, any specific ones that need discussion on?
Mr. Jones, if I might make it just a friendly suggestion, since there are so many complaints and just to keep from hopping around so much, maybe just kind of open it up for each 10 complaints, like, you know, kind of open the floor up and say, does anybody have any questions about the first 10? Then cover that and then go 11 to 20 and so on and so forth till you get to the end. And that way, just kind of keeps it organized.
All right, start on my right, Mr. Collins, you,
Nothing in first 10.
okay.
Nothing in the first 10.
I have nothing, first 10. Okay, well, we go from 10 to 20, 11,
11 through 20, yes.
11 through what?
20.
I have no complaints.
Have no complaint.
Fine.
I have none.
It looks like we are at 21 through 30.
Thanks.
Well, in 22, they was still couldn't have without a license. 22, and down here in 30, they had a New York shop permit, but do they not know the law before they open?
Well, according to the case law, ignorance of the law is no excuse, but there's so many that laws and regulations and everything else that it's estimated that the average person commits 3 felonies a day without realizing it. So it is entirely possible that someone from New York might not be aware of Tennessee regulations.
And then in 29, cosmetologist was doing work in a, you know, like a barber, doing barbering, and she only had, I think there's no excuse for that either. Really, I had complaints with 22, 27, 28, 29, and 30.
Okay. Well, then I'll address them each in turn. Number 22, and this actually brings up a good point. It's kind of something that was new to me that I didn't really know was an option before. There's something apparently that can be done called a letter of information, which basically just says, hey, look, it's a difference from a letter of warning, whereas a letter of warning says, hey, we think a violation occurred, but we're going to warn you but not sanction you. Letter of information basically says, hey, look, we don't even really think we could prove this if it went to a hearing, but you need to know about it because this was something that came up at an inspection or the like. And so with based on number 22, the reason for the letter of information, the allegation was that the shop was open for business to the public. However, it actually wasn't open for business to the public at all. The only reason that the owner allowed the inspector in was because of the inspection. It being a seasonal barber shop, it just simply was not open to the public, and so he wanted to try to be in compliance and allow the inspector to come in while they're in the area and see that everything is as it should be. But in order for there to be a provable violation for operating on an expired license or any kind of unlicensed conduct in that fashion, the way the statute reads requires that it actually be open for business to the public, and it was not. So, but with that said, I still think the letter of information would be a good idea for this licensee, just so that he understands, hey, look, whether it's open seasonally or not, got to have your license. Yeah.
Now, on 27, he was open. His application was in and all, but did he not know that the shop got to be inspected before he opened for business? He was actually doing business before the shop was inspected.
I can't say that I know for sure whether this person knew that or not, because that would require insight into their state of mind that I don't have and the file didn't speak to, but I think it would be perfectly reasonable for the board to presume that someone who is interested in opening a shop should know that they got to have a license first and an inspection first before opening. So the recommendation, again, in this case was for a cease and desist letter, just to tell them, okay, the board is telling you you cannot do this until you got a license. But if the board feels that a civil penalty in addition to that is appropriate, something like $250, and then, got to get a shop license if you're going to operate provision, I would have no problem with that.
Roxanne, let me ask you a question. Do this not stated on the license that they cannot open before the shop is inspected? Is that on the application?
On the application for a shop license, yes, that we have 10 days to inspect their shops. And more often than not, they call, or on the application, they tell us the approximate date as well. So it is on there.
Okay, in this case, they did have the state the shop license was on file.
Well, it says
shop
that the
had-
shop had an application on
Application,
file.
right.
But that's different from having a license, which means that the application would have been approved and the inspection completed at that point. So simply having an application on file, while a good indicator of good faith attempts at compliance, is not the same thing as having a license with an inspection already done.
I had a question on 27, but we covered it.
Mr. High, you had mentioned number 29 as well.
Yes.
Glad to try to answer anything I can for you about that. That was the one with the cosmetologist.
Traumatized, yeah.
So, again, it's no different than number 27. I think this is as good a time as any to remind the board that these are recommendations and that the board may amend them as they believe necessary. And, if the inclination there is to have something a little more stringent than a letter of warning, $250 consent order, and, with cease and desist language to tell them, hey, look, you got to pay this money and you have to stop letting a cosmetologist work here until you've got the dual licensure. That, that's not a problem either. Number 30, the New York person, that's really up to the board. If you want to go with a letter of warning instead of dismissal, I think that'd be just fine. Because in this case, as soon as this particular shop was notified that just having a New York license wasn't sufficient to have a shop here, they immediately came and got their license here, and so I think that's kind of different than a scenario where they're like, oh yeah, well, it's great, Mr. Inspector, that you came by, that's really cool, but I'm going to keep operating and not do anything different and not even try to comply. So, but again,
Excuse me, Chris, I'm sorry, but that does not make sense.
I didn't say it made
Oh,
sense.
okay,
I'm
okay,
just-
okay.
I'm just trying to provide some
I
uneducated
understand.
speculation.
Okay,
So-
okay, okay.
Then, based on the board's feedback, is it the board's sense that numbers 27, 29, and 30 should have consent orders with $250 civil penalties, plus whatever compliance-related provisions need to be in there, or something different?
We'll go with the letter warning on this time. But maybe it should be something stated on our applications that if you open before the shop is inspected, what the results will be. So in that way, they could read that and it would be no question if they come into if the inspectors come into a shop and the shop have not been inspected, the fine would automatically be on there what it actually would be. I think that would be great.
I think it would be more possible to have a statement on the form to the effect of opening and or operating a shop prior to inspection and obtaining licensure, something like shall, sorry, I'm losing words here.
Is that a
Shall
constitutional violation?
subject the licensee to potential civil penalties. And
Yeah.
and so that way,
I
it
think that would
says,
be great.
it would advise them that by doing this, they are running the very real risk of financial penalties in addition to whatever else. But at the same time, that language wouldn't necessarily commit the board 100% to it, but it would tell them, hey, the chances are this is what you're looking at, but also give the board the flexibility to say, hey, look, if there's some really strange extenuating circumstances, then we're not binding ourselves when we think it would otherwise be better to, to give them a break.
Could I add? If I could add, since we're kind of talking about adding some language, for the August 1st combined board meeting, I'm considering doing agreed citations and asking the boards to review all those things such as working before you got your license, working on an expired license. We've increased the number of complaints we're opening with both boards immensely. Part of that is because we've got more field inspectors. We're just doing things differently. We've completed every shop through 2012, almost through 2013, which is great. But that has created such a large number of complaints and given us the opportunity to look at those complaints that are almost just repetitive in nature, that if the board decides an agreed citation, of $250, every time this happens, you just get it. Or the first time it's an automatic letter of warning. So we're working on that procedure to start in August, and I think that'll be a good thing.
And part of that ongoing discussion, and bear in mind this is not finalized yet, as Roxana indicated, but that could also be a way to resolve some of the number of complaints before the new board, before they even come to legal and have to come to the board. Because, if it's pretty cut and dry that, this shop, that's their first offense, they've got, for example, an expired shop license or unlicensed master barber working there or something, and board's like, you know what, that should be $250 a pop for the first violation, $500, and however they decide it, then if some of this comes to fruition, then it may be that they have the opportunity within a certain amount of time, like 14 days or 30 days, to go ahead and just pay the agreed citation. It doesn't even have to come to legal and come to the board because they just pay it and get it done. And then if they don't resolve it within that time frame, then the normal complaint process starts and still provides enough time to have the program comply with its 180-day performance measure. Okay, so I think we are to numbers 31 through 40.
Have no complaint.
I have no complaint.
I have none.
41 through 50.
I have none.
No complaint.
None.
51 through 60.
60. Notice of violation, it was alleged that the area inspector observed multiple sanitation violations at the respondent's shop, including uncovered towels, dirty workstations, and dirty shampoo bowls. I don't see anything here about someone working in there without without being unlicensed or an expired license. So I think maybe that penalty of $500 is too high. I think it need to be $250.
And that's perfectly fine, Mr. Collins. I have no problem with revising that downward. I tried to, when I come up with these recommendations, be as consistent as I can with prior board practice and preference. And so, I'm sure if Mr. Loring was with us today, he might take a different tack.
Exactly, Doug.
But maybe it's this particular shop's lucky day. So if the rest of the board is inclined to $250 for number 60, I can make that revision.
Because see, my only problem with it is that it appears that everybody working in the shop was licensed. I don't read that. I don't read anybody in there unlicensed. All I read is sanitation issues, dirty floors, uncovered towels, dirty workstations. Okay, I just believe a penalty of $250 would be sufficient. That's just me.
Well, and that's perfectly reasonable, especially if you'll note from the date of licensure obtained, this shop's been licensed since 1980.
I noticed that.
And I was a year old at that time. So
I noticed that.
They've they've been around a while, and I don't have any indication listed here of prior
I would hate for
disciplinary
somebody to come
history.
in my shop and see my floors dirty, but I mean, I've been cutting all day.
Right.
But everybody in the shop is licensed. And I haven't had a violation. I've been open since 78, 75. And then I get a bill for $500. I mean, I just personally think it should be $250.
Okay. Any other items on 51 through 60?
No?
All right, so on 51 through 60, and what we'll do is we'll vote on the entire report as amended, and I'll summarize whatever amendments were made through the complaints at the end. But so far, what we have is number 60 reduced to $250 civil penalty, and I think we're ready for numbers 61 through 70.
Number 68.
Okay?
The area inspector observed the manager of the shop cutting a client's hair with an expired master barber license. The shop manager immediately left the shop upon inspection entry into the shop, and it was later determined that the shop manager's master barber license was expired.
That's correct.
And we only finding them $250. I recommend $500
Okay.
because you have two people there when I expired.
Well, actually, if it were going to be a $500 civil penalty, I think the appropriate thought process would be not only was the manager cutting hair on expired license, but essentially fled the shop at
Yeah.
the time of inspection.
Yeah.
And it wasn't until they ran this person's information after they left the shop that they determined it was expired. And oh, by the way, the rules require a manager to be present at all times. So by leaving the shop due to his expired license, he left the shop with no manager. So I think $500 would be fine if the rest of the board agrees.
I also had a question on 62. In this particular case, it appears that they're still not licensed and remains expired since 2013, and that's a $250. $500 would be very much in line there.
Okay, and again, no disagreement there, just again, by way of explanation for the thought process, that when a shop or an individual license has been expired for the length of time more than a year, there's going to be additional late fees and penalties that they've got to pay in addition to everything else. And so, I think 500 probably be all right, but once you get to the 750 range and then you're adding in the additional late fees, it starts to potentially become a prohibitive barrier to reentry into good standing if they want to, because it takes quite a fair bit of work to come up with $1,000 post-tax, and that's about what you'd be looking at with a 750 civil penalty. But I think 500 is fine.
Thank you for that. As I really look at this again, though, it just dawned on me, 2013, that was just a couple of months ago, and all that, 250 might be more appropriate.
Okay. Any other questions?
And I have a question on that particular one.
Okay.
Did the inspector catch anyone working, or just the shop was just open?
It was just an expired shop license.
Just expired shop license? Okay. That's good for me. Okay.
All right. Puts us to 71 through 80.
I have one at 78.
Okay.
78 says the respondent's shop was open for business to the public with no manager present. And according to the inspector, the shop's former manager passed away in 2013, and the shop has not had a manager since then. Do we have any other information? I mean, if all the license is current, and the previous manager has passed away, I would suggest a letter of warning, a consent letter of warning.
And that's fine. And the letter of warning can say something to the effect of citing the rule that requires the manager be present.
Exactly.
And kind of advise them, hey, look, if on your next inspection you don't have a manager present, you're probably looking at a civil penalty instead.
Exactly. That's what I would recommend, because I'm reading too many of these reports where the manager's running out of the shops.
I don't
Okay,
think
at
this
least
one ran
This
out.
one did, I mean, he's passed away, so I'm just saying, I would prefer the board not to fine them, just a letter of warning, since the previous manager passed away.
Okay,
So all he would have to do is just list a manager, right? Just
That's all.
submit it to the state.
just tell us who it is and what their license
Okay.
number is, and provided that it's a
License number.
valid
Okay.
current license,
Okay.
that's all they need to do. Sure. And 81 through 90, that should take us to the end.
I have no complaint.
I have no complaint, but I got a question about. I wish you would explain number 90 to me. I'm kind of confused about that. That just don't sound right. It's talking.
Okay, I can provide a little more insight
Okay.
on that. As Roxana just mentioned briefly, with the higher number of inspectors we have and the better ability to do inspections and handle a little more complaint load, when there are violations against multiple licenses at the same location, whereas before the citation might just be written to the shop. If there are discernible separate violations, for example, you've got 2 unlicensed barbers and an expired shop license. Well, the expired barber license people have also been getting citations as well, separately, in addition to the shop. In this case, the respondent is a extremely young man, early 20s, and as best I can tell, his father is the shop owner, and while that doesn't necessarily excuse the unlicensed conduct, I would say that as between the potentially responsible parties, the shop and/or the dad would be much better suited to know that you own a shop, even if it is your son, you can't have them in here practicing. They gotta do what they gotta do to have a license first, or do their training in barber school. So that's, there are separate complaints open against the shop and the father, but this being the younger man, recommendation for a letter of warning was just what I came up with, so that he knows and doesn't necessarily start his career off with a fine, hefty or otherwise, and a disciplinary record when, for all he knows, it's like, hey, I've been around this shop since I was a kid, and now I'm trying to grow up and participate in the family business, and, maybe I relied on what Dad said that it's okay, and maybe it's not. So.
That is breaking the law. The
Yes.
law is the law. It applies to everybody.
Sure it does. It absolutely does.
Yeah.
And
He was actually cutting hair without a license.
that's correct.
Do we know if he had taken any parts of his exams?
Well, according to my write-up from the file, it says he completed his hours, but not the exam. I mean, again, pretty straightforward, but I'll leave it in the board's hands to decide what to do.
And as Chris said, just to to give you a count, what we used to do before is a citation would be issued against the shop. So the shop would be cited for illegal activity, working without a license. Now it is the shop, the manager, and the individual. So that, of course, is multiplying our cases by 3. So as Chris said, the shop has been cited, and then the manager, whether it was the dad or not, I don't know.
It's the dad who is the owner and the manager.
Right.
So if the board decides to go civil penalty here, I will absolutely write it up that way. However, given that the shop, which for all intents and purposes is the dad,
You have to abide by the law.
Yep.
And they have broken the law. My recommendation is civil penalty for $125.
okay? How does the rest of the board feel about that?
Okay with me.
I think I'd rather see a letter of warning than start a young man out on a better path, but
Would this going to be for the young man or for the
No, it's just for the
man?
young man. The
What
shop
I
and the dad would be starting out probably $250 each.
What I understand correctly is there's already a notice of violation on the shop, as well as the dad,
That's right.
who is the manager.
That's right.
So if we put a violation on this young kid here who's just getting started, that'd be 3.
Yes.
So I think if this young man realizes by witnessing the violations on his dad and the shop, and we send him a letter of warning, let him know you need these license. Okay, I think he'll get the message. Yeah, I think he'll get the message.
But I think that the reason why we're so lenient towards this case is because this is this man's son. Now, if I bring a young man into my shop and he's not my son and he's under the same situation, he's in school and I'm letting him do that, I will be fine. I don't think we should make nothing special. I think he needs to be fine. That's just my recommendation. That's just my recommendation. The law got to apply to everybody. It's got to be fair to everybody.
Well, I will just say that whatever you gentlemen can get to 3 votes on is how I'll write it up.
Because you got 3, because you're gonna have 3 people fined in that shop. 2 we already know.
Right, the shop is fined, right, and whoever the owner of the shop is being hit, and that's
But
what they're
another
doing,
fine,
not only in
right.
this case. So in this case,
Yeah.
it happens to be the dad. So the
Right.
shop has an open complaint, so does the manager.
I feel like only the manager the shop owner should be fined. I don't think the young man should be fined. I think the shop owner should be fined for allowing him to do that.
That's how it would go.
That's how you have it wrote up.
It is.
Right. Okay, good. Okay.
All right. Well, that sounds like 3 for a letter of warning. Unless Mr. Jones.
Yeah.
Okay. All righty. Well, then let me summarize all of these, and if anyone sees anything I've left out, please speak up. Number 1 through 10, 11 through 20, 21 through 30, and 31 through 40, and 41 through 50 are no issues, approved as written. Number 51 through 60, item number 60 is reduced to a $250 civil penalty. On 61 through 70, number 68 is increased to a $500 civil penalty. Number 78 in 71 through 80 is reduced to a letter of warning, and 81 through 90 approved as written. Are there anything I've left out? All right, then I will need a motion and a vote to approve the legal report as amended.
I'd like to make a motion that we approve the amended report.
And I second it.
Moved and proper second that we approve the report as written, as voted on. All in favor by saying aye.
Aye.
Opposed? We use the same sign. The ayes have it. Motion is carried.
Thank
Okay.
you. If I could take a quick moment, I just want to clarify something that I think I actually used the wrong wording. On the school name change that I was referring to early on, it is actually a school ownership change. I want to make sure that we've got that information correct. This is the school that is Music City Barber College. The application is on page 10. It's actually an ownership change, and again, it is for his certification purposes. Music City Barber College LLC is changing ownership from Mr. Uchandi Nawi to International Barber and Style College LLC. That way, both schools that he owns will be under the LLC purposes. And as Chris and I discussed a minute ago, it's not a significant change because he is the LLC on both, so it will not need to be inspected. I just wanted to make sure that I clarified, because I had said the school was changing names, and it's just the ownership piece. Okay?
Okay, I think that's the one
Thank you.
that I inspected to open up.
Yes, and so because, again, he's still the sole ownership, there's not a significant change, so we'll be fine not needing an inspection. That was my concern, so we clarified it. And that's all I have for today, gentlemen. Thank you. We will
Well,
need a motion to adjourn.
Since we have.
Before we adjourn.
Thing, okay.
Before we adjourn, I'd like to say I had the opportunity to visit the Crossville School, and it was very nice, very organized. Just I'm so proud of that school. This is a type of school that we should be proud of. I mean, when I got there, and I don't never know when I'm coming. I arrived and they was in class. Everything was in perfect order, and it's a great school.
Thank you for sharing that.
Okay, I just want to say that glad to be able to serve this board and conduct a meeting for today, and we just hope that Mr. JB continue to improve, and we keep him in our prayers. I also had a brother of mine had to go to the hospital yesterday, and so I had to leave him at the hospital, and my mom in the nursing home, so it's just been a busy time for me, and I just got out of the hospital myself from surgery. I'm doing well. I'm glad to be back with you all since that. So just happy to be here to be able to serve again. And do we have anybody else, anybody in the audience want to recognize? Okay.
I just wanted to ask a question. Is there anything I can do to, like,
Email it if you prefer, but you need that in order to.
Do we have a motion to adjourn?
I can make a motion that we adjourn.
Second.
Move and second that we adjourn.
Thank you.
Social Security.
Chris,
Have a
great, man. Thank you so much.